Morning, Assistant Public Defender Lauren Perry on behalf of Mr. Beach, who is approaching. Mr. Beach,
Where?
state your name, please.
Yeah, Bobby Beach.
Your Honor, we're requesting an adjournment. Mr. Beach, I'm providing Mr. Beach a copy with discovery today. He wants to review it all before next.
Before I adjourn it, Mr. Beach, you had any controlled substance today?
No.
Mr. Allen,
No.
you've had nothing. So if I give you a test, you'll come back clean?
Well, this card right here tells me at your community corrections that I can smoke marijuana and I paid money for it. State of Michigan. Say right here, regulatory cannabis. I pay money, taxes. I should be able to medicate. I just had lower back surgery 2 years ago, St. Joe Hospital. They said either use prescription drugs or use what the state of Michigan provides you, the taxpayers.
Okay. Would that be the only thing that would show up in your system?
That's it, Your Honor. I know.
I'm gonna pass the matter. I'm gonna let him go on his own. Take a test, come back, and then I'll decide what I'm gonna do. Despite your ability to use marijuana on that card, you can't be under the influence when you come into court. You understand that?
Yeah, I'm not now. I just woke up. I'm not now.
Oh, you just woke up?
Yeah,
That's why you
sure.
didn't know where to go in the courtroom?
Yeah, I just had a
Yeah,
daughter.
okay. No, I got you.
I've been babysitting her
Okay,
this
yeah.
morning. I just
Okay,
woke up.
I'm hearing you. I'm gonna trust you to go over on your own. Let's see what the test is.
I'm not smoking coming on court, Your Honor.
Really?
Yeah. I'm not.
Okay, all right.
I'm very
Okay.
coherent.
Okay,
I'm
all right.
appreciative.
Then you probably ought to stop talking and go take your test.
Okay.
All right? Yeah, that way. You better, yeah, get an order over to him.
Just on one time.
Mr. Fisher, tell Miss Perrin he better point the way because he's gonna get lost.
Can I address the court, Your Honor?
I'd advise against it. I've advised him to speak to me first.
You want to address the court, your counsel has advised you that it may not be possible for you to do so, so.
I and my attorney don't see things the same way. So I would, right now, like opportunity to get another attorney.
Okay, and how do you intend upon doing that?
I beg your pardon? I'm hard of hearing.
Can you hear me now?
Yes, sir.
So with reference to an attorney, how are you intending upon doing that?
I'm going to ask to have another one appointed to me.
Well, it doesn't quite work that way.
Okay.
And this is news to me. I did see Mr. Edwards yesterday and there seemed to be no issue.
So you've actually talked to Mr. Brown?
In this whole procedure, I may have talked to Mr. Brown, what? Maybe about an hour, 15 minutes here, 15 minutes there, 5 minutes here and 5 minutes there.
Okay.
This is my first time ever being in court in any type of way.
Okay. So what am I supposed to take from you?
That I'm not satisfied with my attorney. And I think I should have
So what are you not satisfied with?
our communication, my understanding of anything.
Have you been listening to him?
Yes, I have.
You have?
I've been listening to him.
And you're telling me Mr. Brown hasn't properly communicated to you or with you? Because if you're going to say that, I don't believe it for a minute. He's one of the finest attorneys Washtenaw County has So you can go ahead and say what you want, but I'm letting you know the perspective I'm coming from.
No disrespect to Mr. Brown.
Well, you're about to then. Go ahead.
Yeah, that's exactly what I'm saying.
Really?
That I don't understand.
Okay, you not understanding doesn't mean that the attorney isn't doing their job. I don't see a basis upon which to take Mr. Brown off this case. Now, if you want to hire your own attorney, you can go ahead and hire your own attorney.
Okay, that'll be the next procedure that I'll try to do then.
So you're going to try to hire your attorney. How much time you need to do that?
I'm not sure, sir. I don't know.
Well, I got to set a date. How much time you need? You don't like the best that Washington County may have to offer, and now you want to hire somebody else. How much time do you need?
Well, first of all, I gotta try to come up with some money.
Oh,
Okay. Then second of all, I have to have someone to help me find an attorney.
mm-hmm.
Is it a such thing as a promo attorney?
A what?
I may not be pronouncing that correctly, but I'm a lot of dental work done.
Pro bono.
Pro bono attorney, yes.
A pro bono attorney.
Yes.
Meaning one that is a good attorney that you're not paying for?
Yeah.
That's what you want?
Basically, that's what I'm saying. Yeah.
Okay, so you realize standing next to you is one of the best that you're not paying for right now. Yeah, I know. I'm shocked.
I wouldn't challenge that.
You would?
I wouldn't challenge. I said, I'm not saying he's not. I'm just saying.
Oh, so now you're not saying he's not.
I've said what I've said.
Mm-hmm.
And
so to the extent that is even a proper motion to permit withdrawal of the public defender's office and Mr. Brown, that motion's denied. I don't see a basis upon which to do it.
So, Your Honor, what I'm going to ask to do is to adjourn this for 1 week. So that,
1 week?
yeah, so that my client and I can have a chance to talk and find out the nature of his discontent.
Probable cause conference will be adjourned. 1 week has what, the 6th? June 6th, 2024. 9 a.m. as your invite indicates, bond will continue. All right, Mr. Edwards, I'm going to make a suggestion to you before you take those off. I'm going to make a suggestion to you.
yes, sir.
Rather than doing a whole lot of thinking yourself, when Mr. Brown comes and talks to you, maybe you ought to listen to him. And then if you have questions and you may not understand something he's saying, you should probably just ask it. And then you'd have probably a better understanding of what's going on, and we don't have to go through this again. Thank you. Have a great day.
Melton, can you please state your name for the record?
Franklin Joseph Melton.
Okay.
Your Honor, we are asking for an adjournment in this matter as well. The adjournment is as a result of we sent a request for consideration for an offer to the prosecutor. We did initiate the negotiations. We're just still working on those. So I think a short adjournment would do it. Yeah, if the court so allows.
Oh, you done?
Yes.
Any response from the people? Probable cause conference, June 13, 2024, 9 a.m. Bond continued.
Your Honor, if I may briefly.
That's where we were going. Go ahead.
It's my understanding that Mr. Melton has CMH Act Services set up. Tom Kloss is the individual who's assigned to the case to his matter. He has a setup keys and knows where Mr. Melton's going to be staying. Should he get out an offer requesting home confinement was also sent to the prosecutor for her consideration as well to see about a stipulation to the request. And so I would just be asking for your consideration as well. It's my understanding that Ms. Tenha is leaving it to the discretion of the court.
Where would he be?
Up on Gulf side. I have a 2-bedroom up there, sir. Tom from Community Mental Health has the key and is ready for everything for home.
When did that happen?
I'd have to pull up the,
Well, no, when,
I'm sorry.
that's not the address that we have.
I think, Your Honor, that might be the address he set up with Mr. Kloss. I don't know what address that he may have given for arraignment purposes. And I'm certain that that was likely different. Is that correct?
Yeah.
Okay.
Yeah, that was a different one. The person's unable to do anything, but Tom Klaus has the key and has everything ready for home confinement.
So, Your Honor, my understanding, and maybe Mr. Bellinger can correct me if I'm wrong, this was my understanding speaking with him this morning, that this individual from CMH has confirmed that he has an apartment with a key for Mr. Melton. And that if he were to be allowed to home confinement, that's where he would go. CMH not only would have that address, but would be providing him services there. For the record, I don't have any documents. I'm relying on representation by Mr. Bellinger that he has that information.
Why did you get a different address? Oh, because I thought the person might be able to let me stay.
Okay. Understood. Your Honor, to clarify further, during the arraignment, he gave a different address to an individual who he assumed would allow him to stay and reside with that individual. That address that he's now given to Mr. Kloss for purposes of home confinement is an address that he's had for a place that he's had for a year now. So it's his own place.
Yeah, and
On Gulf side?
I'm sorry,
On golf.
on golf side, sir.
He's had that for a year?
He's had his own residence for a year. I don't know what the circumstances were at arraignment to the extent that he couldn't go back there or why he.
What is the Arbondale address?
The Arbordale is where I used to live. I lived there for, I had the address for 22 years. Never missed rent.
Did this get you? Did being in custody get you evicted from that location?
No, no.
Okay.
We were already to golf side.
Okay.
We were already getting out of there.
Who is we?
Tom Klaus was, and we were moving out of there
So was Tom helping you do that through CMH?
through CMH.
Okay.
Yeah, it gets into this whole thing that it
Okay.
does. Yeah.
Your Honor, if I may, just briefly.
Yes, please.
So what we would want for Mr. Melton is to receive CMH service.
Yes, correct.
If he's able to do so in a way that keeps the community safe and keeps him out of trouble, we are all for that. We understand that we always want to strive for the least restrictive means we can do that. If there is a CMH person who has indicated to Mr. Bellinger that he has a key and everything is set up for home confinement, we will leave it to the court's discretion. What I failed to ask Mr. Bellinger, and I apologize, is whether he's had direct contact with the CMH person, or if this is all relying on Mr. Melton's explanation, because there obviously have been some issues with that in the past. So if we can kind of clarify on the record that Mr. Bellinger has been in direct contact with Mr. Klaus with CMH and has received information from him that Mr. Klaus has a key to an apartment that is ready, that would be appropriate for home confinement. We will look at the court's discretion.
Your Honor, it's my understanding that Ms. Baltima from our, the social worker from our office has had and been working with him and has had that direct contact. I have not personally had the direct contact, however, someone from my office has.
Okay, so here's what I'm going to suggest. I'm going to, at this time, deny your request.
Okay.
However, I'd suggest that you work with the prosecutor's office, get that information to them. You've heard their position. And I
Certainly.
think that's an appropriate position, that if there's some place that's safe that is appropriate for home confinement, that's fine. But right now, I don't have anything concrete that says he has an apartment on Gulf Side, and there's a lot of them there.
Understood.
All right.
Thank you, Your Honor.
Wow, what a courtroom roller coaster. Let's unpack what just happened. because this wasn't just about legal technicalities. It was about patience, communication, and accountability inside a system that often feels like it's holding itself together by a thread. The first defendant, Mr. Bobby Beach, walked into court thinking his regulatory cannabis card gave him immunity from basic courtroom decorum. And sure, in Michigan, medical marijuana is legal, but here's the catch. Being under the influence inside a courtroom is still strictly prohibited. The judge handled it perfectly, calm, firm, and composed. Notice how she gave him a chance to take a test and trusted him to do it on his own. That moment right there says a lot about how judges balance empathy with enforcement. But what really stands out isn't just the marijuana confusion, is the disconnect. Bobby insists he's not high, he's just woke up. The judge, half amused but all business, cuts through it. Then you probably ought to stop talking and go take your test. That's courtroom control 101, knowing when to stop a situation before it spirals into chaos. Then comes the second half of this wild session, and if you've ever wondered how quickly courtroom patience can run out, this is Exhibit A. The next defendant, Mr. Edwards, says he wants a new attorney because he doesn't understand what's happening, but when pressed, he can't point to a single thing the lawyer did wrong. The judge's response? Sharp, measured, and honestly, iconic. Not understanding doesn't mean the attorney isn't doing their job. That line alone could be framed and hung in every courtroom across America, and she's not wrong. The attorney standing beside him is one of the best public defenders in the county. The defendant just doesn't get it. This exchange reveals a real-world issue. People often think good defense means doing whatever I want. But in truth, it means protecting your rights, even when you don't fully grasp what's going on. And then that ending. The judge's patience shows again. Instead of scolding, she guides, rather than doing a whole lot of thinking yourself, maybe you ought to listen to your attorney. That's mentorship disguised as judicial authority, and it's something we don't see enough in viral courtroom clips. Now, the final segment with Mr. Melton brings the focus back to the system itself. Mental health, housing, and rehabilitation. His defense argues for home confinement, claiming a mental health caseworker has keys and a plan. But the problem? No proof. The judge, while open to the idea, holds firm. Right now, I don't have anything concrete. This is where the court's cautious balance comes into play, protecting the community while giving defendants a chance to rebuild. Through all the confusion, all the requests for adjournment, and all the back and forth, one thing becomes clear. This courtroom isn't about punishment, it's about structure. It's about giving defendants every chance to stand on their own 2 feet, but only if they meet the system halfway. So now the question goes to you. What do you think? Was the judge too patient, or did she handle these cases exactly right? Should marijuana users with medical cards be held to the same courtroom standards? And when a defendant claims they don't understand their attorney, should that be enough to replace one of the county's best?